Creamer Media's Mining Weekly is speaking to Paul Miller, the director and owner of Amaranth CX. The discussion today is based on the urgent need for transparency in mining.
It's interesting how South Africa has chosen a path uniquely its own on how we go about ensuring transparency in our mining industry. And of course, mining is such an important industry because it's highly regulated, it's prone to corruption, it's prone to tax avoidance, it's a contested terrain. And the question is, why aren't we better at public disclosure around our mining industry in South Africa? And in fact, some of the issues go back to the whole trend or move from what I would call shareholder capitalism to stakeholder capitalism. And we see that in the way that our listed companies have been obliged to improve and change the way they report to society as a whole. In fact, the concept that a listed company reports to more than just its shareholders, in other words, it needs to report to a whole range of stakeholders, is well established globally. Now, it's well established that no major listed company reports only financial information to shareholders. You also have to report on your environmental, social, labor performance. And we see that in South Africa. But in South Africa, we only see it in listed companies and in state-owned enterprises. And that's interesting because surely if your reporting and your interest groups in your company are way more than just shareholders, why is it only companies that have public shareholders that have to report? I mean, think about this for a moment. We have companies that have a high social, environmental, economic significance in our economy, and yet they have no public disclosure requirements. And yet if they simply listed their shares, they would immediately then have to report to society as a whole. And this disconnect is growing ever larger. And I believe the disconnect or the gap between large, significant private companies that have tremendous impacts on society and the environment as a whole, that gap between companies like that and companies that may be smaller and have less significance, but simply happen to be listed, have to disclose far more. And that really makes no sense, right? Surely, if we've moved from shareholder capitalism to stakeholder capitalism, then every company with a significant impact on stakeholders generally should have the same reporting requirements as a company that simply happens to have a portion of its balance sheet or capital as a listed security on a stock exchange. So this gap is getting ever wider. And strangely enough, it's one of the reasons why we have fewer and fewer listed companies. We've gone from 770 listed companies to about 305 that are still trading. At the same time, we're piling on all these reporting requirements onto this ever diminishing group of companies that happen to be listed. And yet giant, significant private companies or companies that don't have more than 100 shareholders don't have to report anything publicly. In the 2008 Companies Act, it appeared to recognize this disjunct between significant companies and listed companies, and the understanding that you can be a significant company without being listed. And they introduced the concept of public interest entities. So now they've got an elaborate method of scoring public interest entities, and there's some consequences that come if you are a public interest entity. One, you might have to have a social and ethics committee, for example. Alternatively, you might have to submit audited financials to SIPC. However, where this gets strange is a public interest entity's documents that it submits are not public. So the public interest is not served by the fact that public interest entities have to submit documents to government. And in fact, perhaps they should be called government interest entities, because what good is that? So what we have then is we have major mining companies in South Africa with significant environmental rehabilitation obligations, with significant tax and royalty obligations, with huge numbers of employees that have no obligation to report to the public on an ongoing basis, even though the mineral rights of South Africa or the minerals of South Africa are held in custodianship for the benefit of all people of South Africa, are licensed to mining companies to mine, and yet those mining companies have no reporting obligations to the citizens of the country whose minerals they are exploiting. So it's a massive gap, and I think it's a significant reason why the number of listed companies on the stock exchange has decreased. And taking it even further, think of this for a moment. You can have a globally significant chrome producer operating 6 or 7 chrome mines and employing 7,000 people in South Africa with a social and labor plan obligation on every mine, with tax and royalty obligations paid to the state, that has no ongoing disclosure requirements, and yet a tiny exploration company with 6 employees that happens to have got listed on a stock exchange would have to apply the full King Code. And it makes no sense that the one with a far greater impact on society and the economy and the environment doesn't have to disclose anything on an ongoing basis, and the other, which barely in operation, has to disclose everything every 6 months. It's not that public companies have an onerous obligation. Public companies probably, because they're significant and they have public shareholders, probably have the right amount of reporting obligations. The problem here is that large, significant private companies have no reporting obligation. That's the problem. When I say reporting obligation, I mean reporting to the public at large, not reporting to SIPC, where the document disappears and nobody ever sees it again. If you're going to ask large listed companies to report comprehensively simply because they're listed, and you are not going to ask socially significant, economically significant, environmentally significant companies to report anything at all, why would anyone choose to be listed if they can find the capital elsewhere? And I think that is a big part of why we're seeing an ever diminishing number of listed companies, not because they have to report too much, not because of what they report is too onerous, but because there's no equivalent requirement for equally significant companies that are not listed. And we've got to close that gap, and we've got to stop saying that a company needs to report because they listed. You know, your stakeholders are not only shareholders anymore. Your stakeholders are civil society, your employees, the environment itself. And if you having an impact on all those things, you should have the same reporting obligations. And we're not seeing that. So I think, you know, for example, in the UK, you can go to Companies House and request for £5 any company's financial statements. And people do that. So you can't hide away simply because you're not listed. In South Africa, you can hide away because you're not listed. And that is a problem. And it goes even further, right? Our state makes it very difficult to access data. So we have no transparent mining cadastre, the system for managing mining rights. So we don't know who has what mining right or prospecting right, where and for how long, and for what commodity and when it expires. That's not public information. It might have been disclosed during the application process, but it's not ongoing public information. Likewise, and this is bizarre, but our mining legislation has no requirement for the beneficial owners of mining rights and prospecting rights to be declared. So anyone can hide their ownership of a mining right or a prospecting right in South Africa. The DMRE doesn't even ask for it. It does ask that 26% of your shareholders have to be HDSAs, historically disadvantaged South Africans. But it doesn't ask who the other 74% ultimately is controlled or owned by. And that's also not reported to the public. So we could have a uranium mine owned by the government of North Korea and the public wouldn't know. To take this even further, there's a third leg to the story. So we know that the reporting in terms of the Companies Act puts listed companies at a significant disadvantage relative to private companies. And it's not that listed companies have to report too much. It's that private companies have to report nothing at all. That's the problem. Then the next step is the state itself is very poor at disclosing what should be public information, like a public cadastre, who owns what, where. They require now that social and labor plans are public, but they don't require that the companies have to disclose who their owners are or what the remuneration of the senior executives are. None of that's required. And then the third step here is how poor our mining industry, our organized mining industry, in this case through the Minerals Council South Africa, is at matching disclosure requirements that would be considered routine elsewhere in the world.
That was Creamer Media's Mining Weekly, speaking to Paul Miller, the director and owner of Amaranth CX.